How do you prepare witnesses to testify at your Social Security disability hearing? Hi, I'm Jonathan Ginsberg. I'm a Social Security disability attorney, and I'd like to talk to you today about witnesses at disability hearings. Not you, but somebody else testifying about you and your impairments. Now, I will tell you that witnesses are somewhat rare in disability hearings. These hearings typically last 45 minutes to an hour, and most of the time, the Social Security Administrative Law Judge is not going to want to spend the time listening to a witness, because a lot of times what the witness has to say duplicates what you've already said. However, there are some situations where your attorney may feel that a witness could be very helpful. For example, if you have a condition that involves, let's say, cognitive problems where you can't think properly, you can't remember things, or if it's a situation where you have severe mood swings that might arise from depression or PTSD, and you're not necessarily aware of what the changes are. Or it could be something where you've got a problem that has changed over time, and you could have a witness come in and say, I knew Sally 2 years ago, and I saw her 2 months ago or last week, and her situation is completely different. She's a completely different person. So in some situations, a witness can help bring perspective to the court. Now, I will tell you that most of the time when a witness testifies, it's only going to be for a few minutes, maybe 3 or 4 questions. So the witness is not going to be expected to go into exhaustive detail about your condition, but again, it can help the judge get some perspective. And I use witnesses a lot of times in cases involving mental health problems, because I think it's very difficult if you are severely depressed or have anger control issues, or you have blackout spells, for example. It's very difficult for you to know exactly what's going on because you're not really aware of how you appear to other people. A witness can really bridge that gap and be very helpful. So when I'm preparing a witness, this is what I tell him or her. First of all, testify only about what you know personally, not about what somebody said. So you don't want to say, Sally here is in a lot of pain, or Sally here has a hard time driving, if you don't know personally. Now, if you know personally, that's something else. Now, for example, you can say, obviously, I see Sally, or you can say to the judge, I see Sally 3 to 4 days a week, and when I can tell she's in pain because she's grimacing, she moves very slowly, she walks with a limp, she will not want to do any kind of activities, won't want to go to the store with me, doesn't really talk very much. I see her taking pain medications, and she tells me that she's in a great deal of pain, and by the way she handles herself, I can tell she's in a great deal of pain. That's an appropriate type of statement. But to say, I know she's in a lot of pain, or she can't do anything because she's in a lot of pain, that doesn't help the judge. You really need to explain why, based on what you have personally observed. And if you've only see Sally once every 3 weeks, don't talk about what she's doing every day, or I know she's in pain every day. Well, if you only see her once a week, once every 2 weeks, you wouldn't necessarily know that. So only talk about what you know personally. Along those same lines, I would tell you that you need to talk about things not in absolutes. So if the judge says, to your knowledge, does Sally drive a car? No, she doesn't drive a car ever. Well, unless you're with Sally 24/7, you may not know that. So the better way to answer it is, I have never seen Sally drive a car. Whenever we have to go someplace, she will ask me or somebody else to drive her. And judge, if she was going to drive, I would not be very comfortable being a passenger, because she has a really difficult time concentrating, and she gets very stressed out when she's in a stressful situation, and has a difficult time functioning or acting rationally in that situation. And she also has periods of time where she simply cannot focus at all. We'll be talking and she completely loses track of conversation. A person like that, I would not want to be in a car with. That's probably a better way to do it. So I think the main thing here when you're serving as a witness is talk about what you know and avoid the absolutes. Spend a little time with the claimant's attorney and practice some of the questions so you'll know how to answer them. Again, you're not expected to testify extensively. This is not your case. You're not the one whose benefits are at issue, but you can be of help to your friend by testifying truthfully. And if the judge says, to your knowledge, does Sally smoke marijuana? Does Sally drink alcohol? Does she smoke cigarettes? Tell the truth. if you say, I've seen her smoke a cigarette every once in a while, tell the judge that, because realize that you are not going to be in court when Sally or anybody else is testifying. You're going to come in cold. You're not going to know what they've said. So if you say, absolutely, she never smokes cigarettes, or absolutely, she never drinks any wine or beer, and Sally's already admitted that she does, your testimony will not be perceived as credible. So tell the truth about what you know personally, avoid absolutes, and give the judge some perspective that will help him understand what Sally is going to from someone who has no dog in the fight, other than, the judge is going to realize you're there to help your friend, but you want to just be as truthful and as speak as much as you can about what you know personally. So hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, follow our channels, and if you've not already done so, go to our website, ssdanswers.com, and grab a download of our free Secrets to Winning Disability Survival Kit. I think you'll find it very, very useful. For now, this is Jonathan Ginsberg wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include, how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know, how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.